This is Wagoner Attorney Stuart Erickson. We're talking about jury trials. Let's talk about the defendant, whether they want to testify or not. First, it'd be their decision. The judge would ask them, even at the time that comes in the trial, do you understand you have the right to testify? Have you discussed with your attorney the pros and the cons? And then basically we'll ask them, do you wish to testify? Because again, you do have that right. Now, should it be a strategic decision? Yes. So let's say you have 3 prior felony convictions within the last 10 years. That's going to come out because that goes to credibility under the law. So if you testify, the first, now I would bring it out on direct and just get it out of the way, but the prosecutor will still ask you, and to try to kind of smear you in front of the jury. Isn't it true you've been convicted of 3 felony convictions? Yes. And their hope is the jurors are going to go, oh man, he's a convicted felon. He's probably a liar. He would say anything. So you do have to make strategic decisions on whether or not to testify. And of course, it would make sense to testify, and you'd have to testify under some, like let's say self-defense. You're going to have to say that I feared for my life. My actions were taken based upon I thought I was going to die. They were attacking me. This is how it started. You would have to get those facts in. It's probably going to have to come from you. Alibi witness is another one, or an alibi defense, that you'd say, hey, I was completely somewhere else. Now, you could have other witnesses too to do that, but you probably want to testify in an alibi defense. That could be me. I was watching an NFL football game with family. It was Monday night. That's what so there are certain times that you would testify. Now, some defendants just always want to testify, give their side of the story. And I've seen that go downhill fast. They just talk and talk and talk, say things that they might not, that they shouldn't have said. And then they get cross-examined by the state's attorney, who may do a good job and may twist their story, in all kinds of stuff. I mean, I've seen defendants take the stand and say, hey, I was the victim of this offense. But the testimony was what the police were called. So, if you're a defendant and you say you're the victim, and you fled from the scene, the prosecutor's going to ask, okay, so you said that you were the victim. Yes. So the prosecutor will go on cross. So you called the police, and the defendant may say, oh, no, I didn't. And you didn't stay at the scene. No, I didn't. You fled. Yes, I did. I drove away. Then in closing argument, they're going to say, if you're the victim of a crime, usually you're the one calling the police. You stay till they get there, and you don't flee the scene. Usually it's the perpetrator that doesn't call the police and flees the scene. So again, you have to be careful when you testify. It's got to be a strategic decision. Now, if you have answers for all those things, heck yes, you can testify to that. But it's got to make sense. You have to listen to what your testimony is going to be and how a jury is going to hear it. It may make you feel better to testify, but again, it's your freedom at stake, prison or no prison, conviction or no conviction. So it's going to have to make strategic sense to testify or not to testify. And that's where you talk to your attorney. You talk to me, and we go through it all. And then maybe you do decide, yeah, it's crazy. We can fight this case without me testifying, or no, we really need my testimony. And then you and I would practice it. We would practice and practice and practice until you get good at it. So whether or not the defense or the defendant testifies is up to the defendant. So if you have any questions about that, reach out to me, Stuart Erickson at WagonerLawyer.com.